volunteer departure, deportations, ways to come back to the US. In this video, I'll talk about how to maximize your chances when you are considering coming back to the US after being deported. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. You're already here. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. Volunteer departure, basically when somebody want to leave on their own, most of the time is when the person sees that this removal proceedings or those hearings are not gonna go my way. Some people just really, they just decided maybe here is not a place that I should live, so I should just go home, and I want to go on my own terms so that I can avoid those deportation bars that comes with deportation, those bars. So what are the requirements? Okay, oh my gosh, what are the requirements? So I was trying to go to my iPad, sorry. What are the requirements? Volunteer departure, basically if you're asking it at the end or at the conclusion of the hearing, basically you have to waive all the requests for relief and then concede removability, basically telling them, yes, I am removable, waive appeal on all issues, and then must not be convicted of a aggravated felony, must not have been convicted of any aggravated felony. I have to reiterate on that. And then show by clear and convincing evidence that you have the financial means to actually pay your own ticket and leave. And that's when you're asking it, before the conclusion of the hearing, okay? When you're asking it after the conclusion of the hearing, you have to show physical presence in the US at least of 1 year prior to you receiving the notice to appear, and then clear convincing evidence of financial means to leave. Basically, you can pay your own ticket and leave, and then show that you're a person of good moral and character for the past 5 years that you have been living here, and then really you can pay a bond as well, and just pretty much show that you are going to leave when it's time to leave. And what are the benefits? One of the benefits is that you are not going to be under those bars like anybody else that has been deported. But there's one caveat to it, is that let's say that you have unlawful presence by the time that you were going to removal proceedings. If it's more than, you know how they say, more than 180 days, at that point, that unlawful presence might cooled or might undermine your case. You might again find yourself under those 3 years or 10 years or 5 years bar. That's just how it works. But at least the chances to find yourself in those bars are less. That's what I want to say. But it's just something to look for when you assessing your case, because you might say, well, I left on my own, so why they're barring me? So pretty much the bar comes with unlawful presence, okay? So, and then let's say the person gets deported, they didn't live on their own, the person gets deported, now they're outside of the United States and they want to come back. How do you assess your case? How do you determine whether it's a good time to apply for permission to re-enter, or basically waivers and so forth? The first thing, you have to look at your deportation order. The person has to really look at the deportation order or order to be removed, what it says inside, because usually it gives you a hint, and they'll say perhaps that you have been barred for 5 years, 3 years, 10 years, or permanent bar. Let's say, for example, it's 3 years. If it's 3 years, what I strongly suggest is for the person to wait. Why? Because at that point, the person has met those statutory requirements, and when they apply for a waiver and the permission to re-enter, basically, it's going to go smoothly. Chances are they're going to give it to you. Chances are they are going to give it to you, because remember, waivers are still discretionary, okay? It really can go either way, but once the person has met statutory requirements, so let's say the bar was for 3 years, 5 years, 10 years, the person has spent all the time outside of the United States, they've met that statutory requirement, now they can request a waiver and prove extreme hardship to their family member. So at that point, the extreme hardship, the case is more likely to be accepted, because at least the punishment has been fulfilled. So the person has already stayed 10 years outside of the US, 3 years or 5 years, for especially for students, 5 years for violations, depending. But that's really, it helps the case. But let's say the person doesn't want to stay for those 5 years, they just want to apply. Well, you can still apply for a waiver. Remember, waivers are discretionary, case-by-case basis, and then they really look at the totality of circumstances when they decide. You can still have the chance, but chances are more for somebody who has met the statutory requirements. So that's what I'm saying. So how can you maximize your chance? You can maximize your chances by really looking into the order of removal, looking into the bar. What type of bar are you subject to? Really, whether it's 3 years, 5 years, 10 years, or permanent. If you have been subject to 3 years or 5 years and you have already stayed outside of the United States for those 5 years, now is the time to apply for that waiver, permission, and the permission to reapply again. Not permission to enter, but really the permission to reapply. I guess it comes with the other waiver on top of the 601 inadmissibility, so that you can really come back. And waiver, I've talked about it too many times on this topic, on this channel. Really, you have to prove extreme hardship, qualifying relative, going to extreme hardship, basically from you being outside of the US, case-by-case basis. Chances are, if you meet statutory requirement, you can be granted that waiver. So that's it for today, and we have one great news for you, my friend. TPS has been extended for Yemen, and again, if somebody's wondering whether the TPS is going to be extended, you just have to watch until pretty much last minute. Congress always do. They always do go ahead and extend those TPS. That's it for today. If you need a consultation for those departure or deportation, phone number is 202-751-2180. Email on display. Consultation fees apply. I really have to reiterate on that one, because people will be calling trying to get me to talk for free. No, my friend, consultation fees apply. We do have live session, and we allow people to ask questions when we have live sessions. Okay, if you call outside of those live sessions, just be advised that we do charge consultation fees. Okay, that's it for today. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. This was US Immigration. Until next time, bye bye.